Well, well, well. Welcome back, everyone. It's time. It's time for your ASMR stream. I'm going to watch the rest of the uh, trial. I think there's about 2 hours left. I'm cozy in bed. It's camera off. There's not going to be any intros, no loud music. So if you're falling asleep, that's just fine. Uh, by the way, have you ever gone to these YouTube channels like this one that's playing? Um, This is the cozy reading nook ambiance with smooth jazz music, rain on window, and warm fireplace sounds. It's fantastic. Um, okay. Anyway, I go to these ambiance channels on YouTube all the time. Freaking love them. I'll drop the link for you so you can go sometime and check them out. There's all kinds of great noises like trains and rain on the window, haunted libraries. There's all sorts of cool stuff on YouTube. All right. Uh, Rob did not. Did he really? He thought Dr. Lewis was a good witness for the defense. Well, I didn't. I wasn't swayed by him. And I try to come at it from as a member of the jury, right? Like, if I'm on the jury, how do I take this? I didn't think he was great. No. All right, let's get to it. Oh, Rumble. Wait a minute. I forgot about Rumble. I got to open up Rumble so that they can have the YouTube link too. Sorry, Rumble. Yeah, it has been a long day, guys. Here's your ASMR uh, YouTube. Go subscribe to some of these ambiance channels. They're so fun. All right. I got to find Maya and get back into where we were. We were listening to motions for a directed verdict by Mr. Burns, or whatever the hell his name is. But no, I didn't think that Lewis was a great witness. Oh, so you guys wanted to know what I thought of the documentary? Well, it was horrifically sad. Um, I don't know. All the recordings that Beata did that we didn't get to hear in this trial are really something. Okay. Here we go. And I definitely think it's worth watching.
Or its employees. And there was a reference to the doctors. It wasn't the doctors. It wasn't just the doctors here, as we know. This Ms. Beatty was a prime actor here. We heard again this morning how she was trying to drive a wedge between the family.
Well, let me ask you the same question I asked Mr. Altenberg. Do you have any case law that discusses the direct versus indirect nature of the conduct and to whom it was directed?
No, Your Honor, but again, the instruction doesn't say anything about that. If the Florida Standard Jury Instructions and this cause of action wanted to say you've got to direct it to the person, they would say that. And what we have here, and again, what about somebody who knows you were? I'm not saying this was happening here. What if you knew somebody was beating your child? You don't see it. You're getting reported. You're hearing about it. You can't do anything about it. Is that not going to inflict emotional distress on the parent? The parent does not have to be the target of what's being done. Now, I think there is evidence here that Beata Kowalski was the target. I don't know who she riled up when she first came to the hospital. We've heard talk about she's kind of aggressive. She wanted this treatment for her daughter and so forth. Certainly, Ms. Beatty, we have her heavily involved. We have her doing and saying things that are, I would say, outrageous. I think it's a jury's call, ultimately, as to whether they would agree with that. But it certainly meets the threshold standard. You talk about, asking the husband, thought about divorcing your wife, get away from this crazy person. That's being the implication. So again, I don't think there's any case law, and I think we heard that earlier, that says it has to be directed to the person who was the ultimate victim. Although there was plenty we've heard about directed to her. And I think that's part of it, to try to take this and break it down and say, well, this little thing didn't do it. Kind of comes back to the part at the end where we're saying, well, there wasn't medical evidence of distress. She killed herself. She committed suicide. Isn't that sufficient evidence of distress?
Right, I'm a little concerned that the defense table behind him, that woman in the purple jacket, was just laughing at him. Did you see that? She's trying to hide her smile. Where did it go?
With that, but it certainly meets the threshold standard. You talk about, asking the husband, thought about divorcing your wife, get away from this crazy person. That's being the implication. So again, I don't think there's any case law, and I think we heard that earlier, that says it has to be directed to the person who is the ultimate victim. Although there was plenty we've heard about directed to her. And I think that's part of it, to try to take this and break it down and say, well, this little thing didn't do it. Kind of comes back to the...
See, look at the blonde now. Look at the blonde. She's going to start leaning over to this one. Then they're going to start talking, and they look like they're kind of laughing.
To the part at the end where we're saying, well, there wasn't medical evidence of distress. She killed herself. She committed suicide. Isn't that sufficient evidence of distress? I don't think you need somebody to say, well, she went and saw somebody the day before that and told them about this or that concern, or told a neighbor. That's not required. The distress here is obvious. And the hospital's treatment, including the hospital employees like Ms. Beatty, only need to be a factor of that. It does not need to be the whole cause. It just needs to contribute to it. And there's certainly plenty of evidence of that here. In terms of the outrageous conduct, we heard again, things that Mr. Kowalski learned up were being reported back to Mrs. Kowalski. She knew some firsthand of things that were going on because she's on the phone calls. She hears what's going on there. The whole show, if you will, the whole thing being orchestrated to separate her from her child, which I realize happens. Part of that you've ruled on, but part of it you've said is fair game for this jury to consider. Those are things that she was allowed, that if you will, are allowed to act as part of this claim.
Is he lost again?
And keep in mind, this situation when she comes in, even those first few days, she had been to the hospital, the same hospital, with the same diagnosis of CRPS before. Why is it suddenly being changed? Why are they not recognizing that? What's the motivation? I think there's plenty there for the jury to say, there's something else going on here. And again, who Ms. Kowalski irritated or aggravated doesn't really matter at the hospital, because this shouldn't have happened as a result of it. If you have more questions, I'm happy to try to answer them, but I think there's enough here to go to the jury. And that's the question. It's not, that's where they are. We're out here. I understand you on the threshold, but think about these things from the point of view of the parent who's being separated from the child, who's being accused of these things wrongfully, we would say. Another question for the jury. And who this contributes to her ultimately taking of her life. So the evidence of distress, I would suggest, is obvious. There's no requirement in the case law or in the, more important, in the jury instruction that will be given that requires it to be directed to Mrs. Kowalski as opposed.
I just thought of something. That lady in the dark purple, the defense knows the dark purple scares Maya. They know that. Do you think she's wearing that on purpose? That was the same color that Kathy Beatty wore all the time. I mean, how sick and twisted do you have to be? You just heard in the last day of testimony before today that Maya is terrified of people wearing dark purple. And then this bitch shows up in the next case, the next day, the next week, next trial date, wearing dark purple. Is that a coincidence? I don't know.
To their daughter. Some of it was directed to her, but
Okay, is there anything else in your argument? I just want to make sure that there's nothing else.
Do you think the judge was telegraphing that I kind of need more than that? Are you sure you don't have anything else to tell me? I mean, what is this really the best argument they have? This is the guy that did the
yeah,
preparing.
there, the other facts, Your Honor, that we heard this morning, the dress, she knew about that. She knew about her daughter being deprived of that, being deprived of religious artifacts, the ability to practice a religion, all those different factors. I mean, denying somebody the ability to practice a religion is pretty intentional. I mean, what is, it's a dress that came from the parents, and you're denying the daughter this, I think it was a holiday, a Christmas dress. You're denying her there. I mean, what possible medical purpose is there for that? What possible purpose is there other than you intended to inflict some kind of harm? Be it on the daughter and the parents? And there, I would suggest plenty of facts here, but I haven't been here for all of them, so let me ask my trial counsel if there's anything else we need to supplement with.
What? Why hasn't he been here very long?
Two risk management notes that are in evidence are worth mentioning in the context of this argument. The first is Exhibit 2277-248. This is the note the court saw yesterday or the day prior, where in the team meeting within the hospital on November 16, 2016, there was discussion that Maya felt that Johns Hopkins was lying to her about her mother, and that the doctors are lying to her about her parents. In the court's statement, I'm not sure if that's the first time the court had seen that note. The court's statement on seeing that note, when relevancy was challenged by defense counsel, was, that's outrageous. A hospital has a 10-year-old child in their custody. They're supposed to be taking care of her. She mentions that they're lying to her about her mother being in a mental institution, and the hospital does nothing about it. That crosses the threshold. The second note is at Exhibit 2277-451. This is a note from December 30th, 2016.
And Mr. Whitney, does that go to the intentional infliction of Maya, or does that go to the intentional infliction of Beata?
Both, Your Honor, if I may jump in. It's getting back. It's getting back to the parents. So I would say both, but sorry.
Agreed. Well, under the argument, there's nothing in the instruction, there's nothing in the case law requires direct action. And this is prior to the December 2nd child abuse hearsay of Mr. Kowalski that was testified to. So this would be one of the things that was relayed to Beata Kowalski in early December. Second note is at trial exhibit 2277-451. And this is a note from December 30th, 2016, where it's noted that Maya has scratches on her forehead for Dr. Elliott. And then the hospital at that point adopts an extravagant theory that this is a possible trap for Dr. Major to have it appear that there's neglect in the care of Maya, not knowing that she had lesion on her skin. We've been through the records juxtaposed against the photographs that Mr. Kowalski was taking. For 2 months, 3 months, the hospital refused to document the lesions on Maya. And when it was brought to their attention, they instead adopted this theory that mom is coaching up the daughter in her limited time so that Maya is self-inflicting scratches rather than the obvious thing that's really happening here, which is she has lesions manifesting because her CRPS is getting worse and she's deteriorating in this hospital's care. So both of those notes from the hospital's risk management file point to the outrageousness of the conduct.
But what if Mr. Altenburn is correct that we have to have conduct expressly directed towards Beata?
And we've been through this at some length today, but for purposes of this part of the record, the conduct that was directed towards Beata are the statements made about her, which she learned. That she should get a divorce, that she was crazy and was in a mental institution, that she was putting her daughter in a coma every week. All of these statements were not made directly to Beata because she wasn't allowed, were funneled to Beata through a proxy, which was her child, her 10-year-old child. And then you have, of course, the direct interactions of her with the hospital and the direct interaction of her on these phone calls with Ms. Beatty, where Ms. Beatty interrupts her at every turn, won't let her pray with her daughter, won't let her ask basic questions of her daughter. Those are actions directed that were experienced firsthand by Beata, is the way to say that. So those are my factual insertions. Thank you.
Anything else, Mr. Elliott?
I think not at the moment, Your Honor.
Sorry.
I say not at the moment, Your Honor.
Any brief reply, Mr. Altenberg, or?
Yeah.
Oh, hold on a second.
Almost.
I've got Mr. Anderson who can't seem to help himself here.
That's all right.
As I see it, the court's concern is what did the defendants do directly to Beata that was outrageous? Granted, this is a little bit different because what you have are telegraph punches. You have, and let's face it, the evidence taken as a whole indicates that there was a desire and plan on the part of Kathy Beatty to separate Maya from Beata, and she so stated. There was a plan by the hospital to force Beata and Maya to change, and Jack, to change their story. I don't think there's any question that there's enough evidence. In fact, we believe it's overwhelming evidence that that was the plan. The next question is, well, what about to Beata? And the facts here are that every single thing that Jack heard, saw, perceived, went to Beata. And so we argue that this was the intent of the hospital. And this is what's so horrible about all this. This was separation of mother from child with knowledge by both and without the ability to combat it. And so what you have here is a plan that is told to the mother that we are going to take away your child and there's nothing you can do about it. There is nothing more outrageous in this society than that. It is a fundamental, not only right, but it is a fundamental part of the human experience to raise your own child. And in this instance, we have people, and there is so much evidence in the record, it's overwhelming, that want to separate the two. And we're trying actively to separate the two. And that, the important thing, judges, that plan, that desire was communicated to Beata over an extended period of time. And if you
Well,
look
but
at
I think to be fair, we need to excise out any contention that because there was reasonable cause for the abuse hotline report, and it was the court that authorized the sheltering. That's not Johns Hopkins, and they're not liable for that.
I understand the court's rule, and I have excised this out, and you saw that with the testimony of Dr. Richards today. Rather, what we're arguing is outrageous, is that over, and it's not the period of time so much as the sequence of events ramping up the pressure on Beata Kowalski, the directives from risk management going through Beatty, perpetrated by Beatty, communicated over, yes, a period of time, but not a period of time about false imprisonment, a period of time to raise the pressure on Beata by hearing about this, this, and this. And if this doesn't get her, let's take away the Christmas dress. And if this doesn't get her, let's suggest that Jack get a divorce. And if this doesn't get her, let's tell her that I'm going to be her mother. All of these things, the evidence in the record is, were communicated to Beata. And so I asked the court to look at the series of events, not from the time, but from the ramp up, the steady ramp up of pressure on this mother, knowing that her hands were tied until, and this has always been our position here, that they intended some reaction out of Beata that would add to their story or serve as the counter, the end point to their story. See, Beata acted criminally and came in and tried to steal her child back, or see, Beata was out in front pounding on the window, or any other outrageous act on the part of Beata that would confirm their theory that Beata was crazy, had Munchausen by proxy, and was just afraid of getting caught. I don't know what the bizarre idea ultimately behind that part is, but I do know that these were doctors and this was a hospital, and they understood that if you continue to keep the pressure on a mother in this circumstance, that mother is ultimately going to break in some form or fashion. And in this instance, what I think is they were surprised, and then I thought, but they weren't, because afterwards they said they expected it and it had happened before. So to our point, Judge, the real outrageousness of this is the systematic nature of the actions against Beata through this. And everything, every contact that she had and everything she learned reinforced that there was a plan to take her daughter away. And that is outrageous in our society.
Your Honor, if I could I tag team in for just one moment to finish up on.
And this is why I
know.
said my preparatory comments about this, because I want to be able to get through at least one of these motions before we have to leave today.
Yep.
So I will let you say it, and then I'll go to Mr. Altenburn for a response, and then we're finished.
Mr. Anderson's ramping up. The last ramp up, or maybe the last ramp up, is January 6th when they take the pictures of Maya, and that is relayed to Beata Kowalski, and she commits suicide the next day. That's my understanding. That not, if I've misspoken on that, I'm sorry, but that's my understanding, is she learned of it. So
She didn't see the photo.
I think there's a question of whether there's any evidence of that issue in the record.
All right.
Okay. Anything else before we go to Mr. Alton? Mr. Whitney,
I'm gonna just make one comment and I'll be done. I apologize.
and I really probably need to like enforce the one lawyer, one argument type of rule, but since I haven't, go ahead, and then I really do need to move on.
The text messages reflect this plan. The comment in the text messages surrounding the EEG video and this targeting of Beata Kowalski is, I wouldn't put anything past her mother. That's it.
Mr. Altenburg.
I think that would put anything past her mother with Sally Smith, if I recall. But first of all, the notion that we are in a conspiracy to target this, A, conspiracy is not in this lawsuit at this moment in time, but B, I mean, it is speculation upon speculation to do this. The notion that these doctors, in attempting to take care of this child, were trying to, that they had some vendetta against the mother is simply not in this evidence. And it's really kind of an insult to the heart, to the hospital. This child came in with reports from the mother and the medical records from Lurie's and Tampa General Hospital indicating that they thought there was a psychological problem going on that was possibly Munchausen's by proxy. That's how this ends up on the front end of this. I think it's important to point out that these two diagnoses aren't all that far apart. We're talking about a situation where a nerve or a muscle or whatever is not in fact damaged, but instead the delivery of the signals from that nerve to the brain are processed improperly in the brain. The CPRS people believe it's this glial cell ops situation, and the people who think that this is a factitious disorder believe that it's done through a psychological process, but nobody's claiming that Maya is faking it that she's making it up. It's that psychologically in her brain, however her brain works, one way or the other, there's something going on that's not real in her legs. It's a diagnosis issue. Maybe the diagnosis was for one or the other is different, but you've heard the testimony from all of the experts that the treatment for these things is physical therapy, occupational therapy, cognitive therapy, and if all that doesn't work as the last resort, you might consider ketamine. So in terms of us having a vendetta against this woman, the truth is we're simply trying to get a treatment package for her daughter that works. It's the court that has separated them from us, and that is just a problem that is very hard for us to deal with. Now, as far as the lesions are concerned, yes, there's a disagreement between the doctors, and you can see it in the medical records as to whether or not we think the little red dots and the little scratches that you've seen are actually things that are consistent with CRPS as compared to something else. That's a medical fight, but that's certainly not something that arises to the level of outrageous conduct. And finally, on the issue of direct or indirect, virtually all intentional torts are things that are done toward a person. The notion that we will have a tort of this sort that is done because of things that are done in the hospital that her husband takes home, that some of which we probably know, but certainly not all of which we know is going home to mother, is simply not enough for this tort. I could say more, but we're going to run out of time. So unless you have more questions, I'm going to move on.
I do, and let me see if I can articulate it. Obviously, the conduct has to be so outrageous.
Yeah.
To me, not giving somebody a Christmas dress might be in bad form, but that by itself isn't outrageous. But given the standard I have to apply on direct verdict, which means I have to take all the facts that are here in the light most favorable to the defense. What about the argument that we see a series of events that arguably are directed to Beata Kowalski, that evidence and intent to maliciously prevent and drive some type of wedge between mom and daughter? And I guess what my question is, am I able to, or should I look at the series of events which singularly might not, like the Christmas dress, might not be itself, or is a series of events, any one of them by themselves is insufficient, but in combination is sufficient? And then I'll let Mr. Elegant comment on that. Or do I need some sort of one overwhelming direct conduct towards Beata, which is necessary to show outrage?
I don't think that the law requires one overwhelming specific incident. It can be things over a duration, but when you look at these things, as you say, that there are a number of things they complain about, like the dress and rudeness on the phone call and whatnot, that don't really accumulate much in this situation. And to claim that those things were done by the hospital because the hospital had some malicious plan to take this child from the parents. The decision whether the child was going to be taken from the parents was going to be made by a court in February based on evidence about medical child abuse. It had nothing to do with what the hospital was going to do in the interim. I don't see why they would even have thought they should have this kind of conspiracy. But moreover, the things you look at, we put her in an EEG room trying to videotape to see whether her conduct would be consistent or not with CRPS over a 48-hour period. We took photographs because she's beginning to have scratches that look to us like scratches and not like something from a disease. She's going out of the hospital, and we don't want to find out what she looks like when she comes back as to whether she has more scratches coming back than when she went in. Those things may seem I don't know, invasive in some fashion, but they're not irrational and they're not designed as a method to be malicious to anyone in that process. So, I mean, by that point in time, there are lawyers everywhere in this thing, and the hospital is just as concerned about this as the family is. And that process in the court is the overwhelming pressure on everyone in this case. So I submit to you that simply when you start with intentional infliction of emotional distress, it is not there. And that certainly when you jump to suicide, a suicide that takes place under these facts, when nothing particular happens in the hospital she knows about in the last 72 hours, and everything particular happens in the court after 100 days there, this can't be a case where we jump from intentional infliction to a suicide caused by that. There should be a directed verdict on both of those counts.
Mr. Elliott, did you want to respond to the question I asked Mr. Altenberg, and then we'll move on after that?
Yes, Your Honor, I agree. It does not have to be a single incident. This is a series of incidents. It starts, as my colleague said, with the threat to arrest her at the very beginning, and it ramps up and up and up. They take away the toilet, move it from her. I mean, all these things. And again, the parents heard about it. The text message after the fact says predicts this was going to be a suicide. It's going to happen. I mean, this is a course, it doesn't have to be a conspiracy. They don't have to conspire to do it, but they did it. And it wasn't just the doctors, it was the staff. Thank you.
I'm going to take the directed verdict motion with respect to counts 21A and B under advisement. Mr. Altenberg, your next one, please.
The next would be count 21C, which is the same count for Maya Kowalski.
So to the clerk, the first one was on 21A and B. This one's on 21C. Count
And
21C.
this count is obviously different because Maya is in the hospital, and there are things that happen direct to her. And as you have noticed, a number of those things may rise to levels of rudeness and the like, but maybe not to extreme and outrageous conduct. The thing I'd like to really emphasize to you is that when the allegations in paragraphs 239 to 240 of the Eighth Amendment complaint are allegations where they go through and say, well, she was battered when she was in the hospital, and she was falsely imprisoned in the EEG room. They go through a list of things that are already the intentional torts that they are alleging elsewhere. Torts that if they prove, are going to get emotional damages. They don't need another tort for this. It's an overlay of that. And so when you take out the things they have alleged in here to make this and the things they claim they have proved here, the things that are left compared to the intentional torts that they have here are not sufficient, I don't believe, to state a claim for intentional infliction of emotional distress. And at a minimum, if this goes to the jury, they need to be instructed that, not only that the damages are not duplicative, I think the damages for the intentional torts they have alleged and this are essentially the same damages. So I don't believe that this count needs to go to the jury. I think it should have a directed verdict.
Assume for the sake of argument that the damages are duplicative. Is this something that the plaintiff would have to elect now, or would they be able to elect later?
Oh, I haven't thought about that. I mean, that obviously on 21A and B, if those two went in, there has to be an election. And the law is on that particular count that it would be an election after the fact. I was frankly envisioning something, if we had to do this, that would just tell them they couldn't duplicate over and over and over again, by the way, in this verdict form. But I know of no law that equates those two in a fashion that would require an election as compared to non-duplication.
Mr. Elliott.
Are you asking about that particular question or
Well,
in general?
I think Mr. Altenberg was finished with his argument with respect to 21C. So your response, and then if you can throw in your comments as to my question.
I would agree that there is no requirement that says you have to, you would get rid of count 21C because it duplicates damages. If there's a duplication, there are ways to deal with that. But there's lots more going on for 21C. You have to keep it in the context that all these things are being done to a 10-year-old girl who's sick, like moving the toilet away from her so she can't get to it. the religious aspects of what we've heard about. So all these things, and they are being done directly to her. So, and she also sees what's going on, with her mother too, but sees or hears. So you have that as well. Again, unless you want to hear more, I think you already know the facts, you know what's going on. I mean, there's plenty here in my view.
I'm going to deny the motion with respect to 21C, the light most favorable to the non-moving party here, the plaintiff. The court finds this to be a jury question.
Okay.
And then we can address the potential duplication issue in the jury instructions when we get there.
All right. Next, I'm moving to count 6C, which is a negligent infliction of emotional distress count, both for Mr. Kowalski and a separate claim for his daughter, Maya Kowalski. They have similar issues, and although Maya's is somewhat more complicated. As I'm sure you know that under the traditional Champion versus Gray and Zell line of cases, you have to have in some fashion experienced a tort that was committed on a close family member, and that has to have caused you emotional distress, and the emotional distress then has to in turn cause a physical injury. The requirement in Brown is that it be one that's such psychological trauma must cause a demonstrable physical injury such as death, paralysis, muscular impairment, or similar objectively discernible physical impairment before a cause of action may exist. So I've cited to you before in Elliott versus Elliott, the first district found that headaches and diabetes and sleep apnea and stress and insomnia, anxiety, loss of appetite, and hair loss, bowel trouble aren't enough.
And I know we've been having this argument
Yep.
over and over. And did I actually write on this issue?
You denied a summary judgment based upon what was there as compared to what we have now.
But did I make, in that denial of summary judgment, did I make comments about the Zell case and these other guys? I'm trying to remember.
I don't remember. The one thing I want to tell you about Zell, though, is because it gets misquoted, I think maybe even in a comment to the standard jury instruction. In Zell, the woman experienced watching her father get blown up by a bomb. She gets severe stomach problems. Those problems get worse and worse. She ends up getting various treatment. She is diagnosed with fibromyalgia and with an orthodontal dysphagia, which is a problem in her esophagus. She gets a medical doctor that says all of this is caused by the stress. In his medical opinion, he says, additionally, in my opinion, within a reasonable degree of medical probability, she has suffered from insomnia and anxiety with a depressed mood. That gets picked up as, oh, that's enough for the cause of action. But that was the additional part that follows things that were enough for medical diagnoses of real physical injury. So the Zell gets taken out of context, and the language in Brown versus Cadillac has never been receded from by the Florida Supreme Court, nor has anyone criticized the language in Elliott versus Elliott. What we have here is he says when he first got on the stand that he had anger, loss of sleep, diarrhea, nausea, and trouble digesting food. That's not enough. He has tired and a little nausea was what he said the second time on the stand. And then he added that he had sometime a couple years afterwards about an eczema that he apparently got treatment for. But the eczema, unlike in Zell, there's no medical doctor that says that there was treatment, there's no bills, and there's no medical opinion that eczema was somehow caused by this particular incident a couple of years earlier. We've heard in the testimony, I think eczema kind of runs in this family to begin with. So I don't think the eczema is enough. And then the last thing we heard was Dr. Brewerton, who evaluated the family for PTSD. And he said, and I was very careful listening to this, based on the events from October 2015 through January 2016, he thought that Mr. Kowalski had PTSD. He tried to make it an organic disease by saying that there's evidence that sometimes that there's a loss of brain tissue in the hippocampus section of the brain. Now, he didn't do any tests on this, on Mr. Kowalski to say there'd been brain damage here. And frankly, there's no medical bills and there's been no treatment whatsoever to this point in time for PTSD. So my position is that from viewing the things that he saw in the hospital concerning his daughter, there are the claim for negligent infliction. Not only is this not tied to that, but none of this is enough to reach the level where this goes to the jury as the physical injury that's required.
And just, I did write on the Champion and Zell, it's the DIN 3133 docket identification number 3133, which is June 26, 2023 order. And basically I agreed with Justice Cantero's decision in Willis that was joined by Justices Well and Bell about the impact rule and its continued viability. So,
Right.
I was gonna say, I remember writing it.
You did right, but I wasn't going to tell you what you did right. Jumping quickly to Maya, by the way, she has the first threshold that what's the underlying negligent act she viewed. There's no negligent claim for the mother. The jury instructions they proposed are the negligent treatment of the parents in the hospital, but there's no jury that has made or will make a finding on that. So I don't think she has the predicate to begin with. But then I listened very carefully to her testimony sitting here, and she talks about all the problems she's had with the CPRS, but I didn't hear a single thing where she said she went to the doctor or had particular problems because she had witnessed something related to her parents. Not even the suicide of her mother is something that she claimed caused something here. There's just simply no evidence that she has had the kind of demonstrable physical injury that is required for this. So I don't think either one of these counts have been proven. We get a directed verdict on both of these.
Thank you, Mr. Altenburn. Mr. Elliott.
Testimony from Mr. Kowalski that testifying to nausea, insomnia, diarrhea, headaches, vomiting, certainly those are physical manifestations.
And I think there's case law that list out those specific ailments, and talking about probably is not enough.
Some of them, I don't know about vomiting is a pretty well, it's a little different than headache. But let me go on to mine. I'll come back and let my more knowledgeable factual counsel help with that. But on Maya's, and we have, we'll be talking to your instruction with you in a bit, but the case law refers to a person hearing. You don't just have to see it. There's not, you can hear something going on that causes emotional distress that's being done to someone else, and you hear it and it causes you the emotional distress. That is sufficient. And she overhears her parents being threatened to be jailed during the first week. She overhears conversations with her mother, where she's being accused, including being accused of things and so forth. So there's plenty going on there. It's not like you have to witness a physical thing happening. Mr. Kowalski certainly witnessed plenty. He had to clean up after his daughter when they moved they fix it so she can't get to the bathroom. So he clearly has that. I don't think we heard that argument, but hearing it is sufficient for Maya's situation. Oh, do you want to?
So this is the plaintiff's opportunity to say whatever they want to say as it relates to this motion.
Now, see, this is the moment where he is supposed to be citing case law to convince the judge that there is case law to support his argument, and he's not doing that. He has nothing. He has absolutely nothing to go against this.
Manifestations, I understand Maya's experts have testified that these things have had an impact on her, physical impact on her, not getting better or getting worse. And I understand Mr. Kowalski also has dysphagia that he's testified to, swallowing difficulty and so forth. So again, that's another, I would say, physical ailment that is beyond simply a headache.
Mr. Anderson, go for it.
You're a very patient judge. I thought that, that Dr. Brewerton went through in detail that the PTSD that they both suffered actually goes in and organically restructures the brain. That is a physical injury. Now, the cause is the PTSD, but I think he testified that the latest data on that indicates that the brain itself goes through a process and rewires itself to keep it to keep these physiological reactions going. That rewiring is a physiological change, and that occurred with both Maya and with Jack. And Dr. Brewerton was very, very clear about that, and that this was related to the what happened to them. So I'd ask the court to take that into account. We now know more about PTSD and the fact that it has a physiological component. Hasn't been addressed by the case law yet, but that's the latest science.
Anything else, Mr. Elliott?
Not that I can think of right now, Your Honor.
And Mr. Altenberg, last rebuttal word.
Very, very briefly, again, this is an account for having viewed a negligent act. They tried to bring in other intentional acts that's never really been alleged, but even if it were alleged, again, the testimony from the experts has been about this whole range of things that goes from A to Z and not the things that happen just in the hospital. And B, that while the theory is that it causes this restructuring in the brain, there's absolutely no evidence that any doctor has ever found that whatsoever in these two people. They haven't even really been treated for this disease in what has it been, 6 years since this event took place. So there is no evidence in this case to present to the jury that there's a physical impairment that's been diagnosed by our doctor or treated, and there is not enough to go to a jury.
Okay, I'm going to take the directed verdict motion with respect to count 6C under advisement. And Madam Court Reporter, I'm going to want the entirety of the arguments on directed verdict starting at 3 o'clock today till the time we finish. I'm going to want a transcript of them. When I say as soon as possible, hopefully tomorrow or maybe Wednesday, if possible. Okay, Mr. Altenberg, you have the floor for the next.
Yeah, I'm jumping to count 18, which is fraudulent billing. Technically, the count is alleged for all plaintiffs, but I think maybe they really think it's only a count for Mr. Kowalski at this point in time. I don't know that it makes really that much difference. This is a count for intentional fraud. It's not a count for negligent misrepresentation or anything else. So they are alleging right out of the standard jury instructions that the issues for you to decide are whether John Hopkins made a false statement concerning a material fact in the bills to the Kowalskis and their insurance companies, and whether John Hopkins knew the statement was false when it made it, whether John Hopkins intended that another would rely upon the false statement, and whether they relied, and whether either the Kowalskis or the insurance company relied on the false statement. And I guess we didn't stipulate on detriment, so whether that caused a detriment to these people. So the evidence you've heard, well, let's start with the basics. Nobody from the billing department at John Hopkins has been called. Bills have just been put into evidence with a number on it, along with a list of other things. And no one from Aetna has been called to say that they thought there was any problem with these billings the way they were done. The only person who testified about them until this morning was Mr. Kowalski. And Mr. Kowalski went through a list of bills from Exhibit 2017, and he would show you that, yes, indeed, that this bill was sent to the insurance company. And so, for example, 17,739 was sent to them with a $90,800 first offer, I guess, from the hospital. And the insurance company paid $50,853. And his theory is that, I guess, we didn't do work for CRPS for them in the hospital. Well, first of all, he doesn't know what was billed for that amount, and he doesn't know whether it's the $40,000 that was taken off that bill, for example. But secondly, it's undisputed that this child was in a hospital room, in a hospital bed for roughly 100 days, and that this child received occupational therapy, physical therapy, cognitive therapy, and things that, without regard to whether this was CRPS or factitious disorder, the treatment was the same for both of them in the hospital. And even their experts recognize that is recognized treatment. They believe that we should have gone on and used ketamine, but they recognize those treatments. So the notion that someone reviewed that bill at John Hopkins and thought that that was a material fact that they were lying about to the insurance company, and that the insurance company relied upon that to pay an amount they never would have paid, or that I mean, the evidence is simply not there. They've not put on the people that they would need to present that. And, then, to their detriment, the only thing they've discussed is a lien, which, if there's a verdict in the way it is, they can argue all that to you at the end of this case, just like they do in every other case to get it resolved there. their other thing is the deductible. They admit it's a deductible for the year. They have no idea what that deductible was used for. And this girl went through a litany of things that year. So there really is no proof of fraudulent billing that can go to the jury in this case.
And let me hear from the plaintiffs, and let me first ask about, is there any evidence that the personal representative of Beata's estate or Jack Kowalski as Maya's parent has suffered any damages? And then we can talk separately about whether Jack Kowalski individually has suffered damages. But is there any evidence on the estate itself being damaged because of the bills?
Well, someone was still owe the bills, Your Honor. They haven't all been paid. Mr. Kowalski, I believe, testified he paid.
Right, but I don't recall hearing evidence that the estate owed any bills, and I don't recall hearing any evidence that Maya Kowalski
No,
owed the bill.
on Maya, I would agree.
Because right now, count 18, I have 3 different plaintiffs bringing the same count, and I'm beginning to think, I agree with Mr. Altenburn, that it probably really, if it exists, is really only Jack Kowalski individually and not the other 2.
Your Honor, we had this discussion a while back about the liens, and we put that into evidence, a little controversy about it. But wouldn't the estate be responsible for some of those liens as well as the PR? I mean, as well as Jack Kowalski as the parent and guardian of Maya?
Was there a claim made in the estate by the hospital? I mean, can legally
These aren't bills for Beata. These are bills for Maya.
Yeah,
So
they were bills for Maya. So
and Beata was the parent.
the parent.
right.
And so was there ever a claim made in Beata's estate for payment of bills? And I don't think there was any testimony to that effect.
I don't think there was either, Judge.
Well, assume that to be true, then if the estate is not legally liable for any bills, then how can it have a claim?
Well, I guess our point is yet, but depending on the outcome of the case, there may well be a claim. And again, we get into the same argument we had before, which is the contingent nature of these liens. And so they can be enforced against either parent, really. So we won't know on that until really it's a chicken or the egg thing.
Well, when it comes to claims in the estate, there's a bar date. And I would submit we are well beyond the bar date, even if the hospital was not notified of Beata's death, which obviously doesn't seem to make sense here. But even if we were to assume that, we're much beyond the bar date. So I don't think anyone can, unless someone made a claim in the estate, I don't think the estate would ever owe any money relative to the bills at this point. And Mr. Elgin, am I
I would say let's talk about Jack.
We understand the court's
Yeah,
position.
let's talk about Jack. Your Honor, there's the big picture, I think, is you've got the hospital telling these parents you shouldn't have CRPS, effectively. Doing more than telling, we've already been through some of that. And at the same time, they're billing the insurance company, I don't know how many hundreds of entries, but apparently for CRPS in the billing codes. And I understand there's an Exhibit 2438 Aetna messages that Beata had with Aetna. So you've got a risk management notes, about the lesions not being complex regional. You've got all this stuff going on that says it's not this, and then you're billing and saying it is. That seems like fraud. That seems like, why are you telling the insurance company this? Maybe there was a higher rate. That's not. I don't think the plaintiffs have to explain why they did what they did. You have that taking place. You have a false statement of material fact. Representatives' knowledge that the representation is false. Well, they're telling on the one hand, they're saying it's not this and they're billing for it. Intention, representation, induce another to act on it. Well, why do you send bills? You send bills to get paid. They clearly intended the parents and Aetna to rely on it. And you have consequent injury by the person acting in reliance on it. Some of these bills were paid. Mr. Kowalski's paid. I understand testified he paid toward one of the bills. There's a big chunk of bills still out there. So I think you have all 4 of those elements here.
Quick response, was there a burden first to prove it was a material fact? Material fact is a fact that makes a difference in the billing. And the only way you do that is putting on billing experts, one side or the other, to explain how these things are billed under the complex Medicare system that we use for billing these days. There's no evidence that this is material. There's no evidence that John Hopkins was intentionally putting something on a bill to defraud them or the insurance company. And without regard to the damage numbers and the like, the front end of this is the problem. They haven't put on the witnesses that they need to do this. I mean, if we have to, we got to put hours of people on the stand from the billing department to explain why this is done in the normal fashion. But we shouldn't have to do that because they haven't come forward with anything to prove that there's a material misrepresentation and that we knew it was false and that we sent it out relying on people to do something improperly.
Madam Clerk, so the court minutes are clear. There's 3 different plaintiffs in count 18. So as it relates to count 18, where the plaintiff is the personal representative of Beata's estate, I'm going to grant the motion. There's no evidence that the estate is responsible for these bills. Therefore, there would be no damage to the estate. And therefore, the count 18 as it relates to the personal representative of the estate is out. With respect to the claim by Jack Kowalski as the parent of Maya Kowalski under count 18, same result. I'm going to grant the directed verdict motion because there's been no evidence that Maya is legally responsible for those bills. With respect to count 18 as it relates to Jack Kowalski in his individual capacity, I'm going to take that motion under advisement. But Mr. Altenburn, have your team call those people towards the end because I'm pretty much in your camp on this. I want to look at a couple of things, but I think count 18 is not going to survive. So I would put that evidence in later. Give me a chance to.
The next count is count 20, which is the fraudulent concealment of the videotape.
Your Honor, can I make one additional point on that? If you're going to continue considering it.
Sure.
The Aetna messages at 2438, there's been this issue as to allocation amongst the various diagnoses. I would only ask the court to take a look at those messages when Deanna Kowalski asked that direct question, what is this billed for? Aetna does not come back with a list of 4 or 15 different diagnoses. They tell her one, complex regional pain syndrome. That's what those bills were for, according to Aetna in their reports.
Well, what exhibit number are those again?
2438.
2438. Okay, thank you. So we're now going on to the next motion, and we're on count 20.
Yes. And this is a fraudulent concealment of the videotape. I'd emphasize that this is not a count for making the tape that is a violation of privacy. And in the allegations in paragraphs 210 to 213 of the 8th Amendment complaint are allegations that we knew it contained exculpatory evidence and that it would be useful in the DCF proceeding and that we had a duty, therefore, to disclose it to them. And that because of that, they had to go out and hire psychiatric and renowned medical experts in an attempt to prove information that JHAC already had on this videotape. Now, for fraudulent concealment, you have to prove that John Hopkins concealed or failed to disclose one or more material facts by not disclosing the videotape. And by the way, the parties have pretty well agreed on these elements. So they're from the tobacco industry has made us a lot of good jury instructions on this. And whether we knew the fact should be disclosed and whether we knew its concealment or failure to disclose the material fact would induce Mr. Kowalski or Beata Kowalski to act or refrain from acting, and whether we had a duty to do this and whether they detrimentally relied upon that information in these circumstances. Now, to be clear, they didn't know we made the video and they didn't know about it until it was delivered to their lawyer on, I believe it's what, the 17th of November, about 30 days after it was made. But the plaintiffs, first, they haven't even put this video in to see what is on it. Other than
I think the video is in. I know there's
two little segments are in, not the whole thing.
4 segments, right?
4 segments. Okay, we got 2 minutes of 48 hours in evidence. And they show various things that we can fight about what it is they mean. But we don't have the whole thing in. But nevertheless, what they really don't have is that evidence from JHAC that anybody in that 30 days reviewed it and said, oh my gosh, there's evidence that is exculpatory. We have to disclose it. There's no evidence that anybody did that or came to that conclusion. And as a result, it should end there. But even if we did that, they have to show that they did something that was detrimental to them. Now, we know that they hired Dr. Duncan, but that was because that was ordered by the shelter court on October 14th at the hearing. They couldn't visit their daughter until those things were done. And I'm not exactly sure when they were done from when Dr. Duncan was on the stand, but my impression was that they were done sometime in early November. There's nothing saying that they hired her to have exculpatory evidence at trial from that point in time. They didn't hire Chopra as an expert until well later than this. So the question is, who got on the stand and said that there were things that were done in the 30 days after November 17th, or even from November 17th to the end of the case, things they would have done in that first 30, either they would have done in the first 30 days or wouldn't have done in the first 30 days if only they had known about the exculpatory evidence that is on this video. And that evidence is simply not here in the record. So without regard to whether the plaintiff is one or all three of these plaintiffs, there's no evidence that there was fraudulent concealment of that videotape.
I think this one is only brought Jack in his individual capacity, Jack as parent of Maya Kowalski.
Okay,
At least that's what my notes have.
okay. So often it says plaintiffs, and I get worried.
Mr. Elliott.
Thank you, Your Honor. I'm sure I'm going to need some factual help on this one too, but let's start with the elements. They had a duty to disclose this under the Patient's Bill of Rights. It wasn't, I mean, there was no medical, as I understand it, there was no notation made in the medical record of this video. So hard to see how they were doing it for a valid medical reason. They wait until after the November hearing to disclose it. They wait 30 days to disclose it. So they can argue about what's exculpatory or what's not, but they concealed it. They kept it from the parents until after that time. And I think Dr. Newberg and Dr. Corcoran both testified to the need to have disclosed this type of thing. Okay, we talked about the medical record. Exhibit 2116, I believe, is that document. It's at one level, it's a little odd to think about how you say you rely on something that was concealed from you so you didn't know about it. But so I think we have to look at what things would have been different. You know, if they'd had this video, they could have used it. You would like to think that the hospital that is treating your daughter, if they had something that helped with the situation, with the true situation, the true facts, they would bring it forward and give it to you. And if the DCF proceeding had really been a search for the truth about what was going on here, that you would have had that evidence. They could always give it to you and say, we don't think it's exculpatory, but they should have given it to them. So their parents were entitled to rely on saying, well, if they'd have had something, they're supposed to be taken care of. They're supposed to have our best interest in mind. That, I think, is reliance right there. I think that's our short response for now, Your Honor. If there's anything else you want me to cover in more detail, I'd be glad to try.
Well, what are you contending the elements of fraudulent concealment? Do you have a case?
Yeah, they're actually, I think let's see, Butler versus Newsom. I think, is that the one? Let's see. I think Mr. Altmark is correct that I think there's a standard jury instruction on that, and I think we don't really have much disagreement over that. So I can
It comes
read
like
that.
straight out of a tobacco case is where it comes from. And somewhere in the jury instructions, there'll be a side to that tobacco case, but I don't have it in front of me.
While he's looking, may I make a few points?
Yes.
Mr. Elliott referenced the Patient Bill of Rights. That's in Exhibit 2045-024, and it sets forth that you or your designee have the right to, and then under 15, get information from your doctor provider about your diagnosis, your test results, and outcomes of care. And that's important because Johns Hopkins has taken position throughout this case that this video was for purposes of medical treatment. And so under the Patient Bill of Rights of Johns Hopkins All Children's Hospital, if that's to be believed, Maya and her parents had the right to be informed about the test results and the outcomes of care, about what was revealed, what were the results, what was the interpretation of this EEG video, and that never happened. You also have the 2 risk management notes.
What are the damages if under that theory that if this was a medical test and then it wasn't told what the results were, what are the damages?
The damages are, it's a bit difficult to say conclusively what would have happened if. We can't know that. But we do know that there was a dependency hearing on November 8th and November 10th. And the parents and their lawyers did not have benefit of this video evidence to go show the court whether or not she manifested behavior that was consistent with complex regional pain syndrome or not. In fact, the justification of risk management notes was that they'd be able to see her walking on her own when no one was there. And that's in 2 different risk management notes, okay from risk. So the damages really are, we've heard several times from the defense here, we can't get into the defense proceeding, and the way for this family to proceed was to bring this to the court. Well, if the video is concealed from them, how can they bring it to the court and get the relief they want, which is, if there's a shelter review hearing on November 8th and November 10th, and the judge sees that Maya is acting in a way completely consistent with her complex regional pain syndrome, it'd be over. The damage is everything from November 8th, November 10th onwards, and even if that ends at November 17th, that Maya remains in that hospital, being mistreated, et cetera, et cetera. That's the damage.
And Your Honor, it's an intentional tort. So I would think nominal damages would be something we would be entitled to in any event. I believe the standard jury instruction is 409.7 for the fraudulent misrepresentation.
And Mr. Altenberg, any response?
Yeah, first of all, the Bill of Rights is provided because there's a statute that requires a Bill of Rights to be provided. And that statute doesn't create a private cause of action. It creates a penalty by the state, and that is it. And so the Bill of Rights has been used here, and I think Mr. Elegant and I have agreed there can be evidence for some other standards, but the notion that we had a duty to disclose under that, A, is not in this complaint, in this count, and B, I don't really think that's legally accurate. But nevertheless, what they're alleging is that it had exculpatory things that would have changed the outcome of the case. Well, they didn't put in the transcripts. So I'll be happy to let you read those transcripts if you want to, but that evidence was going to be used at a trial in February that never took place. And they had it long before that. Their allegations in paragraph 213 is that in reliance on this, they were forced to seek out psychiatric and other renowned medical experts in an attempt to prove this information that we already had. The information they've given you that we already had is 40 seconds of stuff that I'm not quite sure what it proves or disproves. That people are moving and handling this child who's supposed to be in severe pain, and she's not seeming to respond like she's in pain. But be that as it may, there's no evidence that they hired anybody because they didn't have this tape. There's no evidence, frankly, that in the next 30, 40 days after they had this tape, that they hired anybody for the trial where this was going to be the issue. And so they have not proven that. And the notion is that we had a duty to disclose this because it had exculpatory things and we knew it was there. Again, there's no proof that anybody from the hospital had viewed this thing in that 30-day period to evaluate it either as proof in a medical abuse case or even for diagnosis for that matter. They haven't put on any of that evidence.
Court's going to take the directed verdict motion with respect to count 20 under advisement. What's the next one, Mr. Altenberg?
The next one is medical malpractice. It will be shorter, I hope, in some ways, although the part as Sally Smith may not. Plaintiffs have presented this part as practice, any of that evidence.
Count 20 under advisement. What's the next one, Mr. Altenberg?
The next one is medical malpractice. It will be shorter, I hope, in some ways, although the part of medical malpractice case in a very unusual manner. They put no testimony from the primary treating physician. You know, the Dr. Hannah treated this child for 6 months or more and sat out in the hall, but he never ever came in here and spoke a word. So we know nothing other than what is in his records. As far as our treatment is concerned, they didn't put on a single doctor to testify about anything. They put in thousands of pages of records. Those records were used by their experts to review the way experts are allowed to do to render their opinions. So right now, if the jury went out the door, they'd have expert opinions and a big pile of paper. Now, first of all, by the way, that means you can't deny a motion for directed verdict unless you go read it, which you're not going to do. So at least this one has to be deferred, right? But more importantly,
You're assuming I haven't already looked at it.
yes. So, well, I wouldn't have if I were you. But at any rate,
Maybe that's the difference between an appellate judge and
that
a
could
trial
be,
judge.
that could be. But the problem here is that may be sufficient in a case where you're talking about a sponge left in a body or an x-ray that hasn't been read. But we have a case that's about a complex regional pain syndrome that is a relatively new concept in medicine. It's complicated. There was fights about its diagnosis. And then more importantly, whether we should use a ketamine dosage that the experts are coming in here and say, well, the Boston Children's Hospital does this and Nemours does this and everybody else does this. There's a guy in Mexico that does some of it. And there's a couple of offices around here that do this, but the notion that this is generally accepted treatment by doctors, that's nowhere in this record. So my position is, and I'm going to tell you right now, there's no case law that says this, that you should not be able to just throw in 5,000 pages of medical records and put on your experts and tell the jury to go out and figure this out. That's not enough to prove a case. Beyond that, I want to talk about Sally Smith. And I think I might have had a bit of an epiphany Friday afternoon after listening to our discussions on that. And I think that the plaintiffs are conflating the concept of an apparent agent with something that I would call a gratuitous advisor for a treatment team. And this confusion is very likely to create prejudicial error in this case unless we can straighten this out. And the proper way to do this is to DV the sub-issue of whether she is an apparent agent. The case law, not just for medicine, but for a broad range of torts and contract law for that matter, is very, very clear that an apparent agent is if the principal acts or by words or acts holds a person out to be his agent, and the plaintiff relies on that representation in dealing with a presumed agent, and the plaintiff changes his or her position in reliance on the existence of that principal or agency relationship, that then there is a claim. In a non-medical situation, for example, merely being a franchisee of Burger King and having a Burger King sign, that doesn't cut it. But if I'm a yard maintenance company and I have an independent contractor and I give him a big sign to put on the side of his truck that says Altenburns Yards Business, and I give him a cap that says Altenburns Yard Business, and he goes to someone and says, I want to be your yard man, and they say, okay, and he's out there mowing the yard and he runs over their child. He's an apparent agent for them because they relied on him to be one of the guys from Altenburns Yard Service. And I'm going to be liable for him because I held him out by doing all those things to that person. Now, oddly enough, one of the reasons I've never been a big fan of this particular doctrine is the person going down the street. When the yard man runs over a big rock and the rock throws and knocks their eye out, he's not an apparent agent for that person because they didn't do anything in reliance on the fact that he had an Altenburn hat on his head. And so it's a rather weird document. In the medical setting, we started using this mostly because hospitals started taking things inside the hospital and spinning them off to independent contractors. So the emergency room, the MRI unit, the X-ray unit, some other forms of testing groups suddenly all become some other group that's working inside the hospital. They sure look like they're part of the hospital. No one has a sense of they're not part of the hospital. And so when you go to the hospital, you rely upon the fact that the people inside there work for the hospital. And that's the Rosler line of cases. Again, I don't think that's the best solution, but that's the solution, and the legislature's never changed it since I said it was a bad idea. But what we have here is something that's different because Dr. Smith's not running a unit of any sort inside this hospital. She happens to have staff privileges at the hospital, and she's also the head of the CPT team that has a subcontract or a contract, I guess, with DCF. And so what we know is that when this child first arrives and the people in the emergency room or pediatric intensive care hear this story, they're concerned mostly about whether they have to report. They call the person they know is an expert in medical child abuse, which is Sally Smith. She's not an employee of the hospital, but she has staff privileges there, and they know what her other job is. And she gives them some advice. And the Kowalskis know absolutely nothing about that, and they didn't do anything to rely upon it. But that advice was given. And then a while later, after the report to the DCF has been made, Sally Smith has been assigned to be the CPT investigator on this, and she apparently shows up at the hospital. And I gather these interviews with Beata and maybe Jack, at least one of them occurs in the hospital. And she's got the evidence is she has a white coat on that says Johns Hopkins, and she has a tag on that says Johns Hopkins. I can live with that. But what did they do in reliance upon the fact that she has the white coat and that? They talked to a CPT investigator. And from what she heard, but more importantly, from all the medical records that she quickly gathered up, she decided it was time to convince the lawyer at DCF to file a shelter proceeding. And that happened. Now, I got to tell you that if they had realized that she was from the CPT team that day and said, we're not going to talk to you, I don't think anything was going to go one bit better for them. And they certainly haven't proven that they wouldn't have gone to a shelter hearing if they hadn't talked to this person at that point in time. That's a whole different subject. So there was no treatment done in reliance upon her being a member of the employees at Johns Hopkins. Now, from that Friday at the shelter hearing where she appears as a CPT person, at the very latest at that point in time, they know full well that she's not an employee of the hospital. After that point in time, what's bothered you, and I understand why it bothers you, is that the team has collaborated somewhat with her. And when she finishes her report that she files with the court, which is like a 50-page report of all the medical things that this child has gone through in the 2 years before, that's put with the medical records. I guess not in the medical records, but somehow physically with those records. It's a report that's given to the state, but they have that. Now, the Kowalskis did nothing in reliance upon that. Their allegations have been, well, she recommended that a port be removed. I think if you look at the thousands of pages of medical records, you'll see that doctors at the hospital did the same thing. They advised Beata Kowalski that that should be done, and she said no, and they didn't do it. So even though that advice was given, nothing was done in reliance upon that. So what I'm trying to explain to you is that if you're looking at this properly, she's more like a gratuitous advisor to this team. And it's not so much whether or not she is negligent, but if that team itself relies on somebody and what they're relying upon is negligent material, and they should know it's negligent material, they probably breached a standard of care. And so the fact that they were considering this stuff, especially if it was bad stuff, and that an expert would say they shouldn't have relied upon, I'm not disagreeing that that's admissible. It just doesn't have a single thing to do with apparent agency. It's a whole different question. And the reason it's not just this is not a one-off in this case, because lots of hospitals, in addition to All Children's Hospital, have lots of people who have staff privileges at their hospital. People who work for these hospitals call them up for a bit of free advice when they're trying to figure out what to do as hospitalists and the like. If the staff privilege people, who right now the hospital has no liability for, and those people are not on the hook if they answer the phone, if all of a sudden they become apparent agents because they have staff privileges and they're contacted by the hospital, even though the patients knew nothing about it and didn't rely on it, there's going to be a lot less communication from staff privileged doctors. And so there's no reason to go this far when there's a proper analysis to this, just looking at our own doctors and whether they should or shouldn't have taken that into advice and whether that affected their diagnosis or, more importantly, their treatment while she was in the hospital. That's a whole different subject. So I'm moving for a directed verdict as to apparent agency on her, because I do not believe that under the law of Florida that has been proven.
Are you complete with your argument?
Yes.
Mr. Elliott?
Thank you.
Thank you, Your Honor. To start with the medical malpractice, we don't just have thousands of pages of records. We have Dr. Duncan testifying that this was improper psychological care. We have Dr. Chopra testifying that they breached the standard of care in failing to properly treat Maya's complex regional pain syndrome. We have Dr. Newberger testifying to multiple pediatric physicians breaching the standard of care. So there's plenty of direct testimony that John Hopkins committed medical malpractice. You don't have to wait through 5,000 pages of records to figure that out. It's right in the transcript from what I understand. Now, turning to the agency issue. I guess we were talking about pleadings. I say, I don't think gratuitous advisor was pled as a defense, since we seem to be big on pleadings, but I just, it's kind of like you can call it what you want, but she's really an agent, apparent agent, at least, maybe an actual agent from what we see evolving. She is, in terms of what
judgment out the actual agent.
I know you did, but we're hearing more stuff now. And I don't know that we have to go there, because I think we have the apparent agent is clear from what we have. She's escorted into the room, introduced to them, not as somebody from outside, not making no distinction that she's outside the hospital or anything. They do talk to her. You know, I hear the argument today, well, you know, the Kowalskis didn't prove something would have been different if they'd have known the truth. Well, you know, they haven't said, well, the same things would have happened if the Kowalskis hadn't talked with them. That would be something that, you know, that would be a hospital burden. But we have Dr. Newberg again testifying that Jack and Beata Kowalski had reason to believe she was an agent and had authority to act, you know, given her routine presence at the hospital, all the different things she was involved in, including coming in, presenting the way she did with insignia and so forth on. In terms of, and I understand Mr. Kowalski testified that he relied on her presentation. In terms of whether you even have to have reliance, the Rossler case that we're referring to, in which Mr. Altenburn did have a concurring opinion, say maybe we ought to just, you know, move away from this, you know, charade of people. I mean, a lot of times hospitals today want to act like they're just a flea market. They're just renting booths to people to come in and do things, okay? And they're, you know, we don't know what's going on over there when doctor's doing something, but they're not a flea market. And I would endorse, if somebody ever got around to writing it, the view he expressed in that concurring opinion. But the more important thing for our purposes, I think, is the majority opinion. And I don't think we have to go there, because I think there's plenty of reliance, but the majority opinion, if you look at page 1161 in footnote 3, it says that when you show up at the hospital, your reliance is presumed because you have shown up there. That's a second district opinion from 2003. So we think we've got reliance and it's presumed. Now, I'm sure I don't know all the facts. Somebody.
My point on this is, in terms of detrimental reliance, I'd ask the court to consider the testimony of Dr. Kirkpatrick and testimony of Jack Kowalski regarding the fact that Beata and Jack were on guard about misdiagnosis and problems with getting CRPS properly diagnosed. They were on guard about this. They walk in, there's a doctor there. Unbeknownst to them and to Maya, she is actually a prosecutor. You can call her whatever you want, but behind the scenes, her goal is a prosecutor. However, she's wearing a lab coat. It has the Johns Hopkins sign on it, according to the testimony. And she comes in and she doesn't identify herself. And then she takes down the history, which is in the record, but the history is designed to prosecute the Kowalskis. And the detrimental reliance is this. But for her being in there and presenting herself as though in the hospital, presenting her as though she were a doctor, they would have, if they had known she was who she really was, they'd have turned around and walked right out. If they relied on the fact that she was a physician with the hospital who was there to try to assist them and help with the child, but instead she was a secret prosecutor. I submit to the court that had they known on that first time, that first day, they would have turned around and walked straight out of that hospital and none of this would have happened. Had they known Sally Smith was who she actually was, instead of believing, based on the hospital's action, that she was just another doctor there to help. That's my point on it.
Anything further, Mr. Elegant, before I let Mr. Altenburn have any brief rebuttal?
Nothing further.
Anything further, Mr. Altenburn?
I don't disagree that in context of a hospital, if it's a radiology department, the presumption kicks in. That's what that case was about. That presumption hasn't been extended to people who are staff privileges who are called in that fashion. The standard rules apply on that. And what we're talking about is whether she is part of the team for medical negligence. And I mean, the law is just very clear on that as to what would have happened in the DCF proceeding if they had blown her off. That's a lot of speculation, but I mean, her 50-page report on this wasn't based on what they told her. It's what she went and found out with subpoenas to get medical records from everywhere else. So I think that this is an issue that's chasing itself, looking for some relevance somewhere that it just doesn't really have in the suit, and ends up allowing them to make Dr. Sally Smith the evil person, yet another one of our bad people, and that should not be taking place when this case goes to the jury.
The court has before it actually two separate motions for directed verdict. The first is the general directed verdict motion with respect to medical malpractice. The court finds that the plaintiffs have presented a prima facie case, and it's going to be able to go to the jury, so the court will deny the motion with respect to medical malpractice. With respect to the question of apparent agency with respect to Dr. Sally Smith, again, the court finds that there's a prima facie case here, and it's now a jury question on the question of apparent agency. So I'll deny that motion as well. What's next, Mr. Altenberg?
And I'm going to try to do this very brief. Count 14 is the negligent training count. It's hard for me to make a motion for directed verdict because the way it stands right now, we haven't settled on what the jury instruction is, whether it's a medical malpractice standard of care, which I heard opinions this morning within a reasonable medical probability. Right now, the standard instruction given to me is different than that. I think we need to argue about what this claim is before I can, with jury instructions, before I can move for a directed verdict on that. But what I can move for a directed verdict on now is that it is a claim for negligence. And their theory, by the way, is that they can get direct monetary damages here for negligent training without proving that anybody did anything negligent underneath this. And that just doesn't fly. But more importantly, I listened carefully to Dr. Corcoran, who's been their primary expert on this. And if we're looking just at negligent training, there's no physical injury caused by impact resulting from the training. Now, Admittedly, there may be from doctors who committed medical malpractice because they didn't receive adequate training in medical school. I don't think the statute they're relying upon actually requires the hospital to provide more than an hour's worth of training on risk management issues. But one way or the other, the claims here are really claims that aren't separate standalone claims for negligence. This is simply something you can use if you can't prove medical negligence. That I gave you a memo, a motion that we never managed to hear this part of on critical jury instruction issues. That's at, I think, DIN 3396, if I can read my handwriting. But the case law on these training issues is normally in federal cases where the person isn't deemed to be an employee, or in cases where they're otherwise outside the scope and course. It's not in this situation. So in the absence of some evidence from Dr. Corcoran and the like, that not only did they breach the standard of care, but that as a result of that, there was some kind of physical injury from impact on a negligence claim, they don't have a claim here on this.
Mr. Elliott.
Your Honor, I think we have not gotten together on this. I think our predecessor had some conversations, but this, I agree, this is really part of medical malpractice. I mean, that's how you get to part of what happened here. But there is, I understand, testimony from Dr. Brewerton, Henschke, Duncan, and others that the training was lacking here. That some of these things may have been taking place because the doctors, they didn't know how to recognize CRPS. That rolls over into the medical malpractice claim, but that, you know, and perhaps it should be treated as a subpart of that, but that's still a claim and it's still evidence that should come in. So, and again, we're still working on the jury instructions, but that's one that I can easily see how that could be rolled in.
Anything else, Mr. Altenberg?
No, I think that speaks for itself.
What I'll do is I'll take that one under advisement and we'll deal with that on Wednesday at 3:30 when we talk about jury instructions.
Okay. The last thing I want to cover, I don't think it'll take more than 20 minutes or so to get this done, is the battery and the false imprisonment and the related punitive parts of this. That's count 2 and I believe count 5, if I'm not mistaken. And
So are you dealing with them together?
they're very similar arguments, so I'm going to try to fit them in together because they're both claims that result in punitive damage.
So I'm clear, you're moving for directed verdict on the false imprisonment claim, you're moving for directed verdict on the battery claim, and then you're moving for directed verdict with respect to punitive
The
damages.
related punitive damages. And I'm probably not moving for directed verdict on each and every part of this. So I need to break this down for you. In count 2 alleging false imprisonment, it's 3 claims. One for that week of October 7th to October 13th. One for the EEG room on the 18th and 20th of October, and the third for the 2 hours or so on January 6th. And as to each of those, the analysis of the tort and the punitive damage is a little bit different. On the claim between October 7th and 13th, forgetting, there's probably a day in there that I do have immunity for, but I'm not going to worry about that for directed verdict. There is evidence that the family wants to take the child out. This child has been sent there by Dr. Hannah to go to an emergency room. The child is in either an emergency room or a pediatric intensive care unit. There is nobody that's got on the stand as an expert and said that that child didn't belong in an emergency room or an ICU unit during that time period. So for a false imprisonment, the question is whether or not we restrain, the jury instruction on this is whether we, without legal authority, intentionally caused Maya Kowalski to be restrained against her will in a manner that was unreasonable and unwarranted under the circumstances. Now, without legal authority might be a problem in this case for at least a chunk of this time. But
You're talking about the 24-hour issue.
yes, yeah. But the facts are that they brought a child in that had serious enough medical situation, whatever it was, that she needed to be in an intensive care unit at that time, period of time. Mama is not wanting to take this child out to transfer the child to another hospital. There's no arrangements to do that. Admittedly, Dr. Hanna has on his schedule some appointment with a child a day or two later. There's no evidence that he was going to provide more ketamine to that child then or ever in this point in time. So the evidence here is that they want the hospital to roll Maya out in her wheelchair up to the curb, put her in their car to take her home. For a mother who is a nurse infusionist who has IV grade ketamine in her home.
Well, I mean, the reality
Yes.
is though, that there's evidence that Jack Kowalski said he wanted to take him
Yep.
out and was threatened with
Right.
arrest. So does
So-
that kind of defeat your argument? I mean, I understand
Right.
the jury might agree that the balance of the evidence is that there's no false
The
imprisonment.
biggest thing, I figured that you would deny that on the claim for intent. But when you get to the punitive damages claim, those doctors who said, no, we're not letting you out, even if they said, we're going to ask that you be arrested, that the standard on this is that the employee engaged in intentional misconduct. The alternative is gross negligence, but what we have here is an intentional tort, and no one's ever alleged negligence, let alone gross negligence about this event. But when you look at the definitions, intentional misconduct for punitive is the defendant had actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to the claimant would result, and despite that knowledge, intentionally pursued that course of conduct, resulting in injury or damage. I'm sorry, but my doctors in deciding to keep her in the intensive care unit didn't violate the intentional misconduct standard. This shouldn't be going to the jury against them on punitive damages. And that means even if there were proof that there was some management level thing done by the hospital, it shouldn't go to against the hospital either. That this one fails on punitive damages. Now, as to the second one in the EEG room, she has said that she's trapped there. And the full 48-hour tape isn't there, and we haven't discussed it. So I think there's a prima facie case at this point in time that it goes to the jury as to whether or not she was trapped there as well. But the question of whether or not, again, it meets the intentional misconduct of the gross negligence standards. This child had been moved from one room to another room to another room. And by the way, I'm not sure it's accurate, but she's testified there was a surveillance camera in every single one of those rooms. We just moved her into another room with another surveillance camera that was in fact on, and she didn't know it. And so,
Well, I think she testified she was specifically told it wasn't working or wasn't on or something.
Right. And admittedly, the toilet situation was different and all of that. But from the is there a high probability that injury or damage to the claimant would result from that? And I don't think there's enough to go to punitive damages on the EEG. As to the restraint for 2 hours on January 6th, there is evidence that I think is sufficient to go to the jury on the primary count there. The evidence is that the people doing this were told by people above them, but the highest person in this chain is a quote unquote risk manager in the risk management department. Risk management is a term used because the statutes use that term. There's no evidence. Was this Patty Condon? I forget. Patty Condon, what her job description is, what level she is, that they have to have her be at a sufficient management level that she basically speaks for the corporation. And they haven't shown that she's anything other than the lowest person in the risk management department. So I don't think that they have proven by clear and convincing evidence, which is what they have to do, that they have a claim that even if there was something that rose to the level of punitive at the individual employee level, translates to a claim against the hospital because management made a decision that fit within the statute. So I don't believe this one goes to the jury on punitive damages as well. I can run through the battery ones as well if you want to. There's 3 battery ones about the same kind of arguments. So
Sure.
on battery, there are claims against Catherine Beatty or about Catherine Beatty that kind of break into 2 categories. One is that she hugged and patted, slapped, or otherwise gave unwanted affection to Maya Kowalski in the chapel, and I think maybe in some other places. The other is that she committed battery in conjunction with that photographing session on January 6th. I think there's 2 different things going on there. With, again, for the testimony that she gave the hugs and the like, as a technical tort, intent for battery is fairly limited. If you do this conduct and with that the other party would expect to be offensive. And I believe that this is enough to go to the jury on that. But again, when you go to the punitive damages section, this conduct, she didn't hit the child, she didn't slap the child, there's no bruises, there's, not the normal things that one thinks about when one talks about a battery on a human being. And for this to be something that fits into the definition where she was doing something that rose to the level of intentional misconduct, or even though unpledged gross negligence by hugging this child in the chapel and having her on her lap, I don't, under those definitions, this is not enough for punitive damages against her. And equally important, since only the hospital is left in this, there's no knowledge that anybody other than the two of them were involved in this. There's no knowledge that anybody saw these things at that time. So, and there are theories that this was, ratified. The risk management department admitted they knew nothing about any of these things. They couldn't, at the corporate level, ratify this because they didn't even know about these things. So I don't think this goes to punitive damages against the hospital. As to the January 6th incident, I'm not contesting that there's prima facie evidence that can go to the jury on whether or not that's a battery in that situation. As to her, she was told to do. It's not like it was an idea from her. And again, the proof as to where it was that the decision was made and whether that was, it certainly wasn't an officer, director, or the board for this hospital. And the people that they've had, they really haven't, they didn't call them to stand. They haven't done anything to explain at what level they are in the hospital that would make them have the authority under the case law that it takes to be a manager in this situation. They had a duty to prove that by clear and convincing evidence. So I think we're entitled to a directed verdict on
Let
that.
me make sure I understand what you're actually moving for
Yep.
directed verdict. With respect to battery, you are not moving for directed verdict on the hugs and kisses or the photo session. You are simply moving for directed verdict as to a claim for punitive damages for those two
That's correct.
complaints. With respect to the false imprisonment, you're not moving for punitive damages with respect to any of the three instances, but you are moving for directed verdict with respect to the punitive
Well,
damage.
I did move for for directed on the first one.
On the
You-
October
you did-
7th?
I think you denied that.
Well, I think you said that you thought that I was going to deny. I don't
That's true.
think I
Didn't
technically
say I
denied it.
didn't say I didn't move for it. I think you denied that one. The other two, I was conceding on.
Okay, so to be clear, I will go ahead now officially deny the directed verdict with respect to the October 7th through October 13th motion, since there was none made on the non-punitive damage component for the balance. All we really need to talk about is the punitive
Yeah.
damage
I got one more. I'm sorry.
on count 2 or
It's
5.
one more battery.
Okay.
At some place towards, I think it may have been the 8th, towards the end of this, they added language to this that said that when I was asking them to specify more precisely where things were, that unnamed social workers or nurses committed battery by things they did, grabbing, pushing, maneuvering, or otherwise touching Maya Kowalski while transporting her to the EG room or in that room. So in that 2-day period, they're alleging that there was a battery. Now, they were unnamed social workers and nurses. I listened to the testimony of Maya, which is really the only testimony from their side about these events. She complained about a lot of things, but she didn't complain about being battered in some fashion by someone transporting her there. She did in the pediatric care unit, which isn't alleged in this count, which maybe goes to some other count, because that would have been a couple weeks earlier at least. But she hasn't identified anyone or described anything that she thought was a battery. And even inside the room, she didn't testify to something that she thought was offensive conduct by them that should be a battery. So as to that one, I don't think they have proved, not proved, but presented prima facie case, a battery on some unnamed, I don't even know who to call as an unnamed social worker or nurse who supposedly did this, because she hadn't described any of this in her testimony. And then once again, since she didn't describe it to any extent, I don't think it fits within the definitions of intentional misconduct or gross negligence by those people as to this. Maybe they're upset about her being in that room, but as to the batteries, I'm not hearing evidence by that. And I'm also not hearing evidence of the next layer up that one of these, that the management was involved in this, knew about it, or that a mid-level manager or a sufficiently high manager has done anything. So I don't think that this one should go to the jury, both for either compensatory or punitive damages.
Well, let me hear first on this battery with respect to the transport to the EEG room and while we're in the EEG room. Anyone want to, from the plaintiff side, want to give me some testimony that was actually adduced at trial as to that variant of battery?
The battery in the EEG, although they failed to identify who those therapists, nurses, those were, you have this new evidence. You have a situation in which Maya Kowalski is transferred and she's left whimpering and crying in her wheelchair on video, and there's audio of this. So that transfer in the EEG room should suffice. Regarding transfer,
What's the harmful or offensive contact, I should say?
it's the manner in which they're forcing this little girl without pain medication to attempt to support herself and transfer her to the wheelchair. And she's picked up and manhandled and put in that wheelchair, and at the end of it, she's left whimpering and crying. That's offensive to my Kowalski. She testified for pain.
Do you want to hear a legal argument? I'm a little more on that. I'm ready to talk about punitive damages.
Yeah, let's talk about punitive damages.
Okay.
Well, let me short circuit part of it. I'm going to deny that portion of the punitive damage claim with respect to the EEG room and the January 6th photo session for the false imprisonment claim. And I will deny the punitive damage motion with respect to the photo session. I think you need to talk about the October 7th through October 13th punitive damage component. I have denied the motion with respect to the underlying conduct, but I have not addressed the punitive damages, and then address the punitive damages with respect to the hugs and kisses portion of the battery claim.
I think the starting point should be, you heard some talk about, well, this person wasn't a managing agent or this person wasn't whatever level. That's a red herring. You already ruled you're going to give the standard punitive damage instruction on corporate liability.
Right, and for EEG and the photo session, both false imprisonment and battery, I agree.
Okay.
It's just, Mr. Altenberg had a really unique argument relative to that first week, and no involvement of risk management during that.
Well, Your Honor, you have a situation where there is no DCF hold when she first comes in there, and they keep her there. They tell the parents, you're going to get arrested if you take her out of there.
Well, and the false imprisonment claim is going to go to the jury. I agree. It's just whether there's clear and convincing evidence of the statutory requirement for punitive damages for that allegation of false imprisonment.
And let me try to assist here. Maybe it won't be of any assistance. The arguments I heard from Mr. Altenberg was that under the intentional misconduct standard in 76872, we have to show actual knowledge of the wrongfulness of that October 7th, 13th sequestering, holding her there. In the medical record itself, we can demonstrate actual knowledge. They didn't have legal authority. That's at Exhibit 1001, page 63, in which they document at the time that they're threatening his family and holding Mike Kowalski there is no DCF hold in the record. That is the actual knowledge of the hospital that you can then find that there's intentional misconduct.
Well, you need to have somebody high enough on the food chain.
So, high enough on the food chain. We also have in evidence, and I can't cite the exhibit number at the moment, all of the committee rosters of the various physicians that were involved here. And as we said before, it was the who's who of this hospital. We have the testimony of Dr. Vodovoz, for example, who was involved in that first week, and that's the only time she was involved, who was the chair of the ethics committee. That should be high enough in the food chain as a director, officer, executive committee member of that hospital to suffice for 76872. There's a host of them. Dr. Young, I believe, was the chair of pediatrics. You have Dr. Bahar Posey. You have Dr. Elliott. Each of these physicians, Dr. Golan, each of these that I'm naming have committee appointments within that hospital. I can get the exhibit.
I think it might be Exhibit 2142. But that's.
And we have, thank you. And we have, at the beginning of this, we have the testimony of Deborah Hansen at the time, who testified that these were directives coming down for risk management, even in those early days. So we have direct testimony on this issue. And again, the second DCA has found that the risk management involvement was enough to suffice for managerial involvement.
Well, let's be clear, and be fair to the second DCA. They were treating this as a writ of certiorari, and I think they denied it as opposed to dismiss, but I don't think that's,
They denied it. They didn't find it was a jurisdiction issue. They denied it.
so it was denied.
Okay, you're right. It's first thing.
Talk about the hugs and the kisses as far as punitive damages
For battery.
for battery.
Well,
Because, I mean, that one, I'm less confident I've heard anything that risk management had anything to do with telling Ms. Beatty to do or not to, use physical affection, i.e. hugs and kisses, you know,
Well, it
patting
wasn't-
a leg or anything like that.
It's not just physical affection. I mean, she slapped her too. We heard that, right? To test for pain. I'm looking at DIN.
I can talk to.
Okay.
Speak that for a moment. So as the court is aware, there's 3 different avenues for punitive damages under 768-723. And the third is that the employer hospital engaged in conduct that constituted gross negligence and that contributed to the loss, damages, or injury suffered by the claimant. And in the record, you have here Ms. Beatty having disciplinary problems at the time. So you have a corrective action notice. You have a social worker who has a proclivity towards physical contact, physical aggression, and there is no retraining or follow-on or monitoring of this social worker. There's notice from the family and the family's attorney on multiple occasions that they're aware that Ms. Beatty is doing these things, and then there's no follow-up action to those notices that maybe Ms. Beatty should be removed here. So it was grossly negligent to leave a woman like Ms. Beatty in charge of Maya Kowalski and to allow this to happen. And they will notice by mid-November that she had a tendency towards this type of aggression or action towards Maya Kowalski.
And Your Honor, if we can also look at Part B of the standard instructions, because if they have notice of it, then they're condoning it or ratifying it.
Anything else, Mr. Altenberg?
I'm going to go back, by the way, to let's preserve the issue that I started with punitive damages, which is you gave them the option to plead the statute, and they chose to plead willful, wrongful, and malicious. And if I were still under the theory that was in the pleadings when this trial started, I would be entitled to a directed verdict on all of this. But there's no allegations any place in this about gross negligence for any of these things. So I don't see how they get to those standards. And even still, bringing back up the negligent hiring or supervision or retention of Ms. Beatty, which is no longer the case, as part of this, what it was that they claimed the hospital should have done vis-a-vis when these hugs took place. I don't know that we know from the record what date this event such as was. Do we? I don't. But one way or the other, I don't see that this is enough to have clear and convincing evidence that this goes to the jury on punitive damages.
Ms. Carl, just to let you know, we're not going to do evidence after this.
I am judged.
Okay, this is what we're doing with respect to count 2 false imprisonment. For the week of October 7th through the 13th, there was a DV motion made as to false imprisonment. I'm denying that. As it relates to the punitive damage component for that week, I will take that under advisement. Still under false imprisonment for the EEG, there was no motion for directed verdict as to the false imprisonment count, but there was with respect to the punitive damages for the EEG time period, and I am denying the defendant's motion for directed verdict as to punitive damages. That will go to the jury. With respect to the photo session on January 6, 2017, there was no motion for directed verdict as to the false imprisonment count. There was a directed verdict motion with respect to the punitive damages count. I will deny the defendant's motion for directed verdict as that punitive damage claim will go to the jury. With respect to battery, the hugs and kisses battery claim was not made. The punitive damage motion the court will take under advisement. The photo session battery was not, there was no DV motion made, but the defendant did move for directed verdict as to the punitive damages with respect to the photo session, and I'm denying the motion for directed verdict for punies, and that will go, punitives will go to the jury on the photo session battery claim. On the transport to the EEG room and the EEG, I will take that under advisement, and therefore I'll also take the punitive damage component under advisement. But I will think about that. Do you have any other motions? Now, this is what I would like to do, Madam Court Reporter. And I know I'm asking a tremendous amount from you. If I can get this transcript from 3 o'clock to now by mid-afternoon tomorrow, 3 o'clock-ish, 4 o'clock-ish.
Okay, guys, that's it. By my count, and I took notes, the defense lost more of those than they won. I believe they only won 4. Most are under advisement. The plaintiff just won a ton there. So that's awesome. Battery, that's going forward.
the false imprisonment's going forward. Medical neglect is going forward to the jury. The fraudulent concealment of the video is under advisement. So he hasn't decided on that yet. There are several other things under advisement, so we'll find out about those later. But I would say I feel a lot better than I did earlier. Um, so the defense really lost on that one. So, all right, guys, I am dumping you into Rekida's stream because he's still live on YouTube. So go raid Rekida. Rekida, tell him I sent you. See you guys tomorrow on Legal Vices. Johnny Depp. We're doing sidebars. See you then.